Okay. Oh, very well. Okay, so it gives me great pleasure to launch this year's SSLT's Singapore Symposium in Legal Theory 2017, and our first speaker is Dr. Patrick Emerton, who is an Associate Professor at Monash University in Melbourne. His research interests include constitutional, political, and human rights theory, international justice, just warfare, and terrorism. And in 2010, the Federal Law Review awarded him the inaugural Leslie Zines Prize for Excellence in Legal Research. And he will be speaking to us today about legislation as stipulation. So welcome, Patrick.
Thank you, James, and thanks everyone for coming along and for the invitation to give the talk. So, as the acknowledgements indicate, this paper in various forms has been kicking around for a while and had its origins in kind of inspiration by a paper that Kevin Toe gave at Monash a couple of years ago now, where he was looking at fictionalism as a way of understanding legal content. And I haven't tried to take the fictionalism idea any further, but it made me think that just actually stipulation might be a profitable model. And the paper's content and approach is primarily technical. So it's just sort of trying to show, sort of both through establishing some frameworks and trying to give some worked examples, it's trying to sort of show how a sort of stipulation approach to legislation would work. And particularly is trying to show how a stipulation approach to legislation can explain how there is legal content that was never stated expressly, or even, at least in some sense, implicitly, by a lawmaker. But as well as that technical stuff, there's a kind of a bigger picture going on in the background, or actually two bigger pictures. And so the one which this version emphasises, so I thought it might be more relevant for this audience, is that an account of how legal content can arise, although it's never expressly stated by a lawmaker, which shows how this can happen without needing to rest upon moral reasoning or moral premises, provides an answer to some of Mark Greenberg's arguments against populism. And so I think that's interesting. And the other bigger picture is slightly more parochial, because it goes to issues that are very dear to my heart, but probably less interesting to this audience, which is some very long-running and deep-seated debates in constitutional methodology in Australia. So Australia has a very long-standing written constitution, over 100 years old. That constitution has very few express rights provisions, and those provisions it has which are in the neighbourhood of express rights provisions are sort of by conventional standards interpreted rather anemically. So for example, when we had a debate around federal funding of school chaplains, that law was struck down, but not under our anti-establishment provision, which doesn't capture the federal funding of school chaplains, but rather under our public expenditure law. So the question in Australian constitutional jurisprudence of when judges discern implications arising from the constitutional text, are they just making stuff up based on injecting moral reasoning that's not to be found in the text, or are they doing something more like what I describe in this paper, is sort of an important question in constitutional methodology in Australia. And that's another sort of the big pictures that animates the paper, so also the examples are all Australian, and that's partially because that's what I know, but that's also partially because that's where this bigger picture debate in the Australian context is playing out. So it's a fairly long paper, and so in sort of the giving of it, I'll just sort of try to go through some of the highlights and sort of try to get to the gist. So the paper begins with the discussion of, begins with the Greenberg framing. think I'll skip over that for the moment. I think I've said enough in terms of the big picture. In its technical part, the paper begins with a discussion of supposition, because I think when one's trying to understand how the Speech Act of stipulation works and then how reasoning takes place within the scope of stipulation, sort of supposition as sort of an analogue, and if you like, as one species of stipulation is probably the most explored. And so it seemed a reasonable place to start. And so, so the paper works through the toy example. Doesn't work as well in this room, because this room is actually quite a big room. Whereas on other occasions that has worked, because we've been in a smaller room. So we can make it a whale. So the paper asks us to consider the sort of the supposition. Let's suppose, for the sake of discussion, there was a hippopotamus in the room, and then certain further assertions become permissible within the scope of that supposition. And so some of them follow from essential properties of hippopotamuses and essential properties of this room, if we were to imagine it as smaller. Some of them follow from non-essential but nevertheless salient properties of hippopotamuses. So one example I give is, suppose, if we accept that supposition, then we know we could assert the zookeepers will be looking for their missing animal. And the permissibility of that within the scope of the supposition doesn't follow from any essential property of hippopotamuses or of this room, but from another salient and available background of truth, namely that in Singapore, as in Australia, hippopotamuses live in zoos, and zoos have zookeepers who look after their animals. So, the general structure of reasoning within the scope of a supposition, and therefore within the scope of stipulation, is the background commitments which are available within the scope of the supposition or the stipulation, together with the stipulated or the supposed content, entail conclusions to be drawn. In some contexts of supposition, the same pattern obtains, but the reasoning engaged in is slightly different. And I'll provide this example. You have another animal, I've got no horse in the race of what is the most intelligent breed of dog. I take this example from Stephen Barker's book Renewing Meaning, where he uses it, for whatever reason, as an example, sort of generality. So, if someone asserts if a dog is a collie, usually it's intelligent. So, they're committing themselves to the permissibility of the consequent within the scope of the supposition that the dog is a collie. From that, we can infer what the background commitment is that they are committed to in virtue of producing this as a permissible permissible assertion. Namely, they're committed to the claim that collie dogs typically are intelligent. So sometimes reasoning within the scope of supposition isn't supposition plus background to consequence, but the commitment to the consequence following from the supposition permits us to infer to the background. So, stipulation, so like supposition, involves reasoning of the same general pattern, but the S is not supposed, it's stipulated, it's deemed. And naming is a sort of fairly canonical example of stipulation. And when you look for workless stipulation, of which there's not as much as one might have suspected, naming comes up as sort of the standard case that gets discussed. and both naming of natural entities, so the paper discusses a cat example, it's called by cat should be called Felix, also naming in the mathematical context. But as in the supposition examples, so in the stipulation examples, the performance of the stipulative speech act then permits certain other, makes certain other speech acts permissible within the scope of the stipulation. Now, permissibility within the scope of the stipulation isn't necessarily confined to performing assertions within the scope of the stipulation. So I give the example of the child's game, so from which you may correctly infer that I have reasonably young daughters. So I'll be a fairy, you can be a mermaid, and then certain further assertions do become permissible within the scope of that stipulation, but certain other acts might become permissible or obligatory or impermissible. So I give some examples in the paper. For example, maybe the one who's a fairy has to go like this when she moves around the room. But the focus of the paper is on the permissibility of speech acts within the scope of the stipulation, because particularly if we're thinking about law, the vehicle for law is linguistic. And so the permissibility of speech acts has particular salience. Now, the question of what the speech act of legislation is has sort of been widely discussed. So, Marmor, in the language of law, says that speech act, the speech act of legislation is exhortation. There's a fairly lengthy footnote in which I explain why I don't think that's very plausible. I think that falls foul of the same objections as are generally used to strike down at least crude, expressivist, emotivist accounts of moral language, namely that exhortation isn't sufficiently robust in inferential and counterfactual sorts of contexts. And it also has issues around moving between psychological states and non-psychological reports of the content of the law. So I think all those, and I think I cite Mark Van Rooyen in particular. I mean, Rooyen's made his career demolishing every version of expressivism or emotivism that gets put up, showing that it's not sufficiently robust. And I think the same sorts of arguments he uses there cut against Marmor's suggestion. I mean, so my own mentor, Jeff Goldsworthy, suggests imperatives, that these have got the problem that they're not truth-apt and they don't have the right sort of structure to figure in argumentation or inference. So I think one sort of immediate strength of thinking of the legislative speech act as stipulation is that it's not problematic how it figures in argument and inference, because we have an already very well established example of stipulations underpinning argument and inference available, namely sort of mathematics and sort of logic in general, where so we're very familiar with that sort of stipulative starting point then feeding into an argument in mathematics, or sort of similar sorts of stipulative starting points feeding into argument and inference in sort of in logic more generally. So I think it's one initial sort of virtue of the stipulation account that it makes the speech act of legislation familiar to us rather than opaque in terms of its capacity to figure in reasoning. The next, sort of again, just some initial thoughts about the starting point of stipulation. The next feature, consequence of the stipulation account, which personally I regard as a strength, but I know when I've presented this paper before, others have regarded it as a weakness. And so I'm sort of interested to see what this audience thinks, is that it doesn't make law or legal content sort of inherently normative in its kind of syntax, in its semantic content. So that's not to say that it severs any connection between law and normativity, the final section of the paper has a bit to say about that, and then how that fits into some of the Greenbergian concerns about law and normativity. But the stipulation account doesn't present the connection between law and normativity as upfront or inherent. Now, one of the reasons why I think that's a virtue is that, firstly, I think it makes the account less vulnerable to the sorts of objections that Greenberg runs against the standard picture. But I think the stipulation account is not a version of the standard picture, I think. And so I think it doesn't fall foul of the objections to the standard picture. On the other hand, if you don't think those objections are very strong, and I know, for example, that James doesn't, then that may not excite you very much. Another reason that I think it's a strength of the stipulation account that it doesn't treat the contents and all the syntax, all the semantics of law as sort of first and foremost normative, is I think it has a much easier time accounting for the huge chunks of legislation that on their face are not normative in their content. And again, going back to the second of the two big pictures I mentioned, that this is especially dear to my heart as an Australian constitutional lawyer and theorist, because when one's working with the Australian Constitution, one's working with a text that isn't normative on its face in most of its provisions, and yet one wants to say a lot about it and the legal significance of its content. But I don't think the prevalence of non-normative legislation is kind of unique to Australia. So I think the various provisions that I've given here, I think provisions like this sort of could be found, I think, in any system at least that approximates to sort of common law norms of legislative drafting. So I don't think there's anything here that would be odd in British legislation to the extent that I'm familiar with it, and I don't think there's anything here that would be especially odd in American legislation to the extent that I'm familiar with it. So the first example comes from the Australian Constitution, and it doesn't state any norm, on its face it doesn't state any norm or rule of conduct. It establishes a jurisdiction. The second constitutes the existence of a body. The third, which I want to say a bit more about because I think it's quite interesting, the third looks like it has a connection to a norm of conduct, namely certain conduct being an offence, but it doesn't itself state any such norm, but it's conditional. This is a provision, so again, some of these examples show I also work on Australian anti-terrorism law, and so I'm fairly familiar with some of our anti-terrorism legislation. So this is an example which clearly does state a norm of conduct. A person may not fail to give information, for example. So I don't want to say there's no legislation that's sort of normative in its content, but I don't think that that's particularly distinctive or even necessarily particularly common in legislation. So, having made those sorts of preliminary observations about the stipulation account, so kind of is what it is in outline, so it's claiming about the speech act of legislation, some initial features which are presenting as strengths, but I recognise that they might be seen, particularly the non-normativity might be seen as a weakness. The paper then goes on, so I'll go on now, to sort of make some technical moves. And again, I think it's a strength of the stipulation account that it can make these technical moves. Again, to the extent that one thinks that technical moves are sort of uninteresting or simply kind of technical glosses of what was in any event obvious, then the stipulation approach will be of kind of less interest than it is to me. So one of these, again, very important in Australian constitutional reasoning, but I think not only that, is implied mandates of existence. So I'll go back here, and so we can see the second of those examples is an express mandate of existence that brings a body into being. The first is well understood in Australian constitutional law to generate an implied mandate of existence, namely that Australian states must have supreme courts. So it's very well understood in Australian constitutional jurisprudence that that provision, and some similar provisions which use very similar language, which talk about the Supreme Court of the various states of Australia, Australia, a federal jurisdiction. So it talks about the Supreme Courts of the various states. That's taken to mandate the existence of those courts, and hence, therefore, to limit the legislative capacity of state parliaments to abolish those courts, or to so radically change their character that they would no longer answer to the constitutional description of Supreme Court of the state. And there's then a sort of a question, well, how does that mandate get generated? And so one notion that gets used is, so Jeff Goldsworthy likes the idea of an implicit assumption that they exist, which he likens to a sort of a Gricean implicature. The difficulty with implicit assumptions is you get dual content issues, and then and in some of the content are generated by implicature, then you get issues around embedding and availability and inference and that sort of thing. So I'm not a big fan of implicit assumptions. In general, I think communicative accounts of legislative content, a bit like Marmor's exhortatives and Jeff's imperatives, aren't sufficiently robust under conditions of inference, embedding, wanting to distinguish psychological from semantic content and that sort of thing. The stipulation account has a fairly ready explanation of where the mandate of existence comes from, namely a Strawsonian-style existential presupposition within the scope of the stipulation. So in the debate between Russell and Strawson around Strawson's paper on referring, Russell's replies reproduced in my philosophical development, their debate was whether the failure of the existential presupposition gives falsehood, which is Russell's view based on his semantic treatment through his theory of descriptions, or whether it gives unavailability, which is Strawson's preferred view. I've got no sort of a pawn in my loyalties here. I'm a big fan of Russell, but Strawson's got some good points as well, but I can be agnostic on that, which is in the context of assertion, but nevertheless put forward an account of what's happening in the stipulation context. Right? Because in the stipulation context, it's not assertion. And so the question of truth availability under conditions of failure doesn't come up. It's stipulation, which is to say, in the scope of the stipulation, the stipulated content is deemed to be available and permissible. Hence, if its permissibility depends upon the existential presupposition, that is also available within the scope of the stipulation. So this is a case where, in effect, the S and the C let us recover a B, namely that Supreme Courts of states exist. And so the stipulation approach, I think, has a fairly handy technical account, which doesn't involve wheeling out any new linguistic phenomena. It simply involves noting how a well-understood linguistic phenomenon, an existential presupposition, works within the stipulative context to explain for the kind of implied existential mandate. The next of the sort of the technical examples I want to mention is the third one. So that is that's a very, very standard way of defining an offence in Australian law, and especially Australian federal criminal law. Again, I'm not sure how familiar it is from other jurisdictions. But the striking thing about it is it doesn't state a norm of conduct. It's a conditional. It's a general conditional. If a person does such and such, then the person commits an offence. So in fact, its sort of basic syntactic and semantic structure is the same as the collie dog sentence, only the adverb of generality is always rather than typically. No. In the same way that in the collie dog example asserted by someone, we can understand their commitment to like the supporting background content. Typically, collie dogs are intelligent. So in this case, again with the adverb generality being always, not usually, not typically, if that is deemed permissible, because that's the content of a stipulation, then the salient background commitment, a person who does such and such commits an offence is recoverable within the scope of the stipulation. And so that's how this conditional stipulation defines norm of conduct, even though itself it doesn't express any such norm. And so then that's sort of a technical point and a technical analysis, but again, I think it's an interesting feature of the stipulation account that it makes it easy to see how these hypothetical, these conditional constructions, when performed as stipulations, permit a norm of conduct to be recovered, and so it can be seen as defining an offence, even though they don't expressly state any norm of conduct at all. Then skip over this for the moment. We may or may not need it. Let's go through it. The final two examples I want to mention are the two slightly more elaborate ones, because these are the ones which are meant to directly answer some of Greenberg's points. So one of the points that Greenberg presses very hard in his anti-positivist arguments, so legislation is communication, so his paper in the Scott Soames and Andre Marmor book is one place where he pushes this hard. One of the things Greenberg pushes very hard is that it's well known that there are various interpretive presumptions, which he points particularly to the assumption of a fault element for a statutorily stated offence where there was no fault element expressed in the statutory statement of the offence. I don't think Greenberg himself discusses the principle of legality, but I think he, looked up through Greenberg's lens, would raise some very similar sort of concerns. And he certainly thinks that communication theorists don't have the resources to explain how these principles interact with statutory content to generate the content of the law. And I think in this, the standard picture of discontents, I think he doubts that the standard picture, with its focus on the content of the law as the content of an authoritative communication or an authoritative proclamation, thinks that sort of picture can't account for it either. So in the two sort of longer worked examples, I'll try to show how the stipulation account can explain how, if you like, one can accept Greenberg's point that legal content is generated which was never stated by the lawmaker, but show how this might happen without needing to appeal to the sort of moral reasoning that he says must be the only thing available because it's not there in the content of the communication. So the first example is, it's from a very, very significant, both legally and very politically significant land law case in Australia. So there were statutory grants of leases. So this was one of the means whereby sort of colonisation worked in Australia, was the grant of leases over the wastelands of the Crown, which also were the places where Aboriginal Australians had been living for some time. And there was a question whether the grant of these leases under the Queensland Crown Land statutes had extinguished native title, so Aboriginal title in respect of these lands. And this therefore became a question of statutory construction, particularly what's the meaning of the word lease as it appears in these statutes, and hence as it sort of characterises a form of land tenure that was granted to various leaseholders. And a reference to sort of a simple reference to parliamentary or to legislative intention didn't itself contain much of an answer, because the legal proposition that native title had subsisted in certain Australian land wasn't articulated authoritatively until 1992 in the Australian case called Mabo, whereas these Crown Land Acts had been operating 80 to 100 years before then. So the lawmakers had no awareness that the status of native title rights was up for grabs as a consequence of the tenures they were conferring by statute. And so what I do in the paper is try to sort of reconstruct the reasoning in what I take to be the leading judgment, in the case the judgment of Justice Gummo, who will be known to James at least as a kind of a leading Australian equity judge. And again, taking, in the context of Australian constitutional and legal methodology disputes, taking Gummo as one's paradigm is sort of nailing certain colours to the mast. So he would probably be seen as sort of the most influential formalist in the past 20 or so years on the Australian. He retired a few years ago. So from when he came onto the court in late 1996 through to his retirement, he would be seen as the most influential member of the court, I think, and as a certain sort of formalist. Again, and so one thing the stipulation account can be seen as doing is trying to articulate in a sort of theoretically rigorous framework the tradition of Australian legal formalism. So I think, I hope that most of that is sort of reasonably clear as it stands. The key moves that Justice Gummo made in his decision, he had to make two moves. He had to show that the word lease, as it appeared in the statute, was open to more than one reading. We had to show that the word lease that appeared in the statute was open to more than one reading. At which point, going back to this, the way I sort of formalised that is he had to show that the question of how the word lease, as it appeared in the statute, the question of how that word got its reference, was up for grabs. That kind of reading the statutory text and reading the legislative history didn't on its own answer that question. Roughly, option one was that the statute was coining a new term. So the statute was itself engaging in coining a new usage, a new reference of the word lease. Whereas option two was that the word lease was being used in the sense in which Putnam refers to with a division of linguistic labour. So the second option was that the word lease carried with it the meaning it inherited from its long use in English land law. And the way that Justice Gummo shows that these two alternative readings are open is by looking at the legislative context, looking at the way various sorts of land tenure were being talked about in various other statutory regimes extant at the time, both in Australia and in other common law jurisdictions. And so he shows that there's nothing about the context, the legislative history, the way tenure was being talked about at that time in other decisions, in other jurisdictions, so this is kind of in the middle to latter part of the 19th century. Nothing about that settled this question. Both are sort of open readings of the statute. And once you have that open, right, so B6 here, once you have both readings open, the principle of legality, so C1 here, tells you to prefer the reading which will minimise the burden on pre-existing land rights. And so what's going on here is that the principle of legality is an available sort of background commitment in conjunction with B6, that the reference of the word lease in the context of the statute is open as between the B4 and the B5 readings, then entitles us to infer to C2 that the word lease refers to a novel statutory kind of tenure, not to the traditional lease of English land law, which is to say that it's a type 1 rather than a type 2 referential intention. So I think that's the structure of Justice Hamo's reasoning. It shows that, I think, working through that example, I think shows a couple of things. It shows how the stipulation account differs from the more typical communication type accounts. That, for example, Marmor, Cliff Goldsworthy, Larry Solomon, Scott Soames, Stephen Neal, Krapauskis and others all favour. On a communication account, the idea that part of your reasoning is identifying the referential content of what's being communicated will be sort of almost contradictory. On the communication account, if at the first stage you discover that two readings are open and on the evidence available nothing settles that, the communication account would have to say, well, the communication was ambiguous, hence the law's indeterminate, hence whatever other reasoning happens downstream is sort of construction type reasoning. At which point Greenberg says, well, yeah, it's almost always like that, hence the idea that you're going to get significant amounts of legal content without needing to rely on moral reasoning isn't going to come through. The stipulation account has no problems in saying, well, here's what's been stipulated, namely that a certain sort of lease has been created. But the reference of one of the term lease isn't fully circumscribed. It's like inherently in the stipulation. But other background commitments might be available from which we can then engage in further reasoning to settle the question of referential content. So, to give a sort of a parallel from the toy hippopotamus example, if we are supposing there's a hippopotamus in the room, we're only allowed to move to the permissibility of the zookeepers will be looking for their animal if, within the scope of the stipulation, we're allowed to draw upon the non-essential feature of hippopotamuses in Singapore, namely that they live in zoos. And the question of whether that has been carried through by the reference, again, itself might be settled by the content of the supposition itself, but other background commitments might be available to help settle that question and settle the issue of reference in that case too. So I think the idea that questions of referential doubt can be resolved within the scope of a supposition or within the scope of a stipulation, I think is not particularly absurd or curious, and shows how the principle of legality works in these sorts of cases without needing to invoke sort of some moral commitment to the undesirability of the rights extinguishing reading. But there's a big question which the paper doesn't address, which is how does the principle of legality become available as a background commitment? In his reasoning, Justice Scully answers that by pointing out, notwithstanding it was already well understood principle of interpretation at the time these Crown Land statutes were enacted. So he shows that it's already there. But the question of its origin is a very significant question, and the paper doesn't address that question. The other worked example is about the issue of sort of reading in fault elements to a statutory offence. And for reasons of time, I won't go through this, which is actually the preamble part of the paper's account. I think the interesting part of the paper's discussion of this is that what you find within the scope of the supposition is a commitment to two projects. So the Parliament has stipulated that certain conduct is to be criminal. So there's, if you like, one project stipulated. The interpretive principle, which is also available, is a commitment to a project about the relationship between impugning conduct and agency. So roughly, the more severe the impugning of someone's conduct, the more we have to be satisfied that their agency was fully engaged in relation to the conduct. And then the application interpretive principle becomes within the scope of the supposition, attempting to integrate and reconcile these two projects. If that can't be done, then the presumption has been rebutted and there is no fault element to the offence. If that can be done, then the reconciliation will tell us that there is a fault element, and ideally, as we look to see what sort of reconciliation is possible, we'll establish what the fault element is. My feeling is that Greenberg would doubt that you can engage in the process of reasoning through the reconciliation of two projects without kind of involving ground level moral commitment. Again, the more toy example the paper offers to try to suggest that one can do that is giving an example of an essay question. So the essay sent to philosophy students. So, can a Lockean be a pacifist? That's the sort of essay question one might well set, right? And that's reasoning through the commitments of two projects and attempting to reconcile them. If they can be reconciled, then the answer is yes, Lockean can be a pacifist, and the reconciliation will tell us exactly what that means. And if they can't, then the answer is no, Lockean, it turns out, can't be a pacifist. For example, they're committed to the permissibility and certain the obligation to engage in arms insurrection in certain contexts. So, and I think the claim that students in answering that essay have to engage in kind of their own ground level moral reasoning rather than taking the two projects on the table and integrating them within the scope of stipulation. I don't think that's particularly plausible or appealing as account of what's going on there. So the fact that, as philosophers, we do this all the time, reasoning through the kind of compatibility of the projects aimed at goals and so on, I think lends some credence to the possibility that likewise, within the scope of a statutory stipulation of a certain project, a certain criminalisation project, but also with the background commitment to the mens rea project, that the reasoning through those could be done without having to engage in sort of ground level moral reasoning of the sort that Greenberg says is involved in working through these interpretive presumptions. And then the paper concludes with some sort of further reflection, some of which I've already gone through in talking about the sort of the big pictures. The only one of those I think now that I should probably mention is, can the stipulation account connect to any sort of interesting or plausible story about laws normativity? And very, very briefly, sort of thinking one paragraph, the paper suggests that the answer is yes, that the stipulation account, one might think of it, it's a sort of a technical working out of Weber's idea of sort of modern state legal systems as sort of legal rational authority, and enjoying their legitimacy in virtue of that, so he contrasts them with traditional and charismatic forms of authority. And I think, right, if one wants to ask how does a stipulation account connect to a story about law's legitimacy or law's authority, I think that Weberian picture is the bridge. And again, whether that makes the account seem more plausible or more absurd, to some extent, it's an exercise for the reader. But again, for someone from a very formalist legal culture, which Australia is, I think more so than New Zealand, more so than Britain, a fortiori more so than Canada, and then even a fortiori than the US. Right? So very, very formalist. So from someone who does come from a formalist legal culture, that doesn't seem necessarily absurd. So that's the picture, that's the paper. I'll stop there.
Thank you.